Get ready for the dictation in 3, 2, 1, start. In compliance of the aforesaid order, the petitioner approached the medical board constituted by the Director, All India Medical Sciences, New Delhi at 10:30 am on 11th July 2020. The said medical board has submitted its report dated 11th July 2020, which reads as under. All India Institute of Medical Sciences, New Delhi 110029, examination of petitioner Miss Neha Devi to render an opinion about the condition of the fetus and as to whether the termination of pregnancy would be safe in the case of the petitioner or not, including the likely physical and mental consequences to the petitioner in both eventualities, in compliance of order dated 10/7/2020 of Honorable the Chief Justice and Honorable Mr. Justice Prateek Jalan, High Court of Delhi, wide WPC number 4104/2020, titled Neha Devi versus Government of NCT of Delhi and another. In compliance with the letter dated 11/7/2020, Medical Board meeting was held on 11/7/2020 at 12 noon in MS Office, AIIMS, New Delhi. The board consisted of the following. Neha Devi came to the MS Office, AIIMS on 11/7/2020 at 10:30 am for the medical board as directed by the Honorable High Court of Delhi for opinion on the above mentioned subject. Medical board met in MS Office Seminar Room, ground floor, AIIMS, and Miss Neha Devi was examined and her medical records were evaluated by the panel of experts in the committee. The learned counsel for the petitioner submitted that the petitioner had undergone 2 more examinations and has annexed copies of the reports. The first report is dated 22nd June 2020, of which is at annexure P2 of the memo of writ petition, and the details of the said report reads as under. Fetal biometry, morphology, and genetic sonogram performed. Gravid uterus shows a single live fetus in variable presentation at the time of study. Internal is closed. Cervical length is 32 mm. Placenta is posterior, well above the placenta shows grade 1 changes. Retroplacental region is clear. Liquor amni is adequate in amount on this study. Miss Sneha Mukherjee, learned counsel appearing for the petitioner, categorically states that her client has been made fully aware of the situation, including the condition of her fetus and the possible risk in case termination of pregnancy is to be allowed at this stage, and that her client is willing to undertake the risk of termination of her pregnancy, but would not desire to allow the pregnancy to continue given the condition of the fetus. The petitioner, who was 24 years of age, approached the Supreme Court under Article 32 of the Constitution of India seeking permission to undergo medical termination of her pregnancy, which had progressed to 24 weeks, as her fetus has been diagnosed with tricuspid and pulmonary atresia, a cardiac anomaly. The Supreme Court constituted a medical board to examine the situation. The board reported that the treatment of the abnormality in the fetus would require fetal surgery, which carried the risk of high mortality, and that even if the surgery were to be successful, such children would remain physically incapacitated and had a limited lifespan. The Supreme Court observed that except for the time period, that is, the duration for which the pregnancy had continued, the case would fall within Section 3(2)(b) of the MTP Act. In the circumstances, the Supreme Court held, thus, in these circumstances, it is difficult for us to refuse the permission to the petitioner to undergo medical termination of pregnancy. It is certain that the fetus, if allowed to born, would have a limited lifespan with serious handicaps which cannot be avoided. It appears that the baby will certainly not grow into an adult. Stop. Thank you.